Now, more with Ross Kaminsky on Denver's Talk Station, 630 KHOW.
All right, happy Monday, everybody. Those of you who are listening in the 9 a.m. hour on Friday would have heard a guest I had on this show, Susan Greene from the Colorado Independent. We were talking about a lawsuit that she is trying to bring. They're actually going for cert in front of the Supreme Court of the United States regarding judicial records here in the state of Colorado, which the state Supreme Court has said are not subject to CORA requests, and the state legislature has not done anything about it, despite some efforts by Republicans. So we're talking about whether judicial records should be subject to basically Freedom of Information Act requests. And then my guest, without my knowing she was going to do this, said, well, the records we were trying to get that started all of this were about prosecutorial misconduct in the 18th Judicial District that started under the previous district attorney, but then continued with George Brauchler and about the Sir Mario Owens case, I think it was. And I was kind of taken aback. And it was late in the show. I didn't think it would be possible to get George Brauchler on the show to respond with just a very short time left in the show on Friday. So I invited George to be here today to respond to allegations that I thought were pretty aggressive, and I thought it would only be fair to have George on the show to talk about it. So George Brauchler, DA of the 18th Judicial District, good morning. Thanks for being here.
Hey, thanks for having me on, Ross. I appreciate it.
Well, so you heard what I just said. Why don't you respond as you see fit?
Well, I mean, first off, as a district attorney and as a conservative, I am committed to the idea of transparency in government. In fact, I don't think there's a DA's office out there that puts as much information about the inner workings of our office up online and easily accessible as we do, including making those open records requests achievable online without ever having to set foot in our office or write a check. So I'm committed to this, but this is not that issue, Ross. In fact, when you say judicial records, I think it makes people think about, wow, why can't we know about judicial HR matters or how much taxpayer money they spent on that desk in the Supreme Court or any one of those things. Those things, absolutely. What we're talking about is a pleading in a case that is ongoing and currently in the post-conviction process right now. And it's not me that has said that this is a record that shouldn't be revealed at this time or that shouldn't be made public. It's not only the district court, but the Supreme Court twice that has said this. But again, it's not a record like any other judicial record would be. It's a part of an ongoing case in the post-conviction appellate review. Now, look, Susan Greene, if you take a look at anything that she has put out on that blog, man, she is anything but independent or unbiased, especially when it comes to me and the DA's office. If I had my own blog, that wouldn't make me a journalist, and people would be suspect about the things that I say about certain political opponents or other things. I get that. But this has become a bit of a crusade for Susan, and I get that. And I respect that she has the absolute right to do it, and I appreciate that she's doing it with support from, I don't know who else contributes money to make that thing happen. But I'm interested in knowing what the law is on this issue as well.
So what I would like you to address specifically, George, is because she said that the records she was seeking demonstrated prosecutorial misconduct by your predecessor and by you in withholding exculpatory evidence, which I think is one hell of a charge to make on my radio show. And she said that some other judge has already said that it's true that there was prosecutorial misconduct in this case. So can you please tell us what she's talking about?
Yeah, again, if you look at it from the political standpoint, all of these wild accusations make total sense. What she's referring to is the post-conviction order by Judge Christopher Munch, who came and spent, my gosh, over a year rehearing a million different parts of the case of Sir Mario Owens to come back and find that we, in fact, and maybe it was Robert Ray, that we, in fact, still get to maintain the death penalty, that it's still in place. And then it goes on to the AG's office and the Supreme Court after that. But whatever errors the court found, one, are completely public and have already been reported on, and two, never amounted to enough to call into question the validity of that death penalty. So when she throws out these sexy, teasy words and stuff like that, keep in mind all of this is in the public sphere. All of this has already been reported on, and all of this has been considered by a judicial branch, which is charged with not doing what I tell them to do, but doing what they think the law compels them to do. When it comes to this other case that's out there, it'd be interesting to know if Susan would concede that someone has shown her these otherwise suppressed documents by the court, because that would in and of itself be its own violation. So without getting into the details of them, I'll say this. Hypothetically, any defense attorney can make any allegation about a prosecutor, about a witness, about anything, stick it in a pleading, and then potentially, hypothetically, run to a media outlet they think is favorable and say, hey, pull that out of there, and then let's have a conversation in public about judicial records, and I'm using air quotes as I talk to you, supporting allegations of prosecutorial misconduct. Look, the court has these records. The court has whatever's in those pleadings. The court is going to, if it hasn't already, consider all those things. This is just merely an attempt to get some salacious media stuff out there to try to make something out of this that is going to be, my guess is, ultimately revealed to the public once the courts have made the decision what to do moving forward with the bigger part of the case.
George, we've got about 90 seconds left. We learned late last week that there was a mistrial declared in the case of a guy who has been charged with criminally negligent homicide of a Colorado state trooper, and there's been a lot of talk in the usual echo chamber about, you know, what this means for you or your office. Can you tell us what this means and why a mistrial was declared, which seems unclear in some of the reporting?
Yeah, sure. There was a couple things. One was an email that had been sent to my prosecutors that indicated that a witness 2 years after making observations that he was going to testify to was enrolled in a commercial driver's license class. The court thought that that was relevant enough that that revelation should have been disclosed to the defense. I respectfully disagree, but I'm not the judge. And then the other one was an expert who'd issued a report that did not contain a specific fact that she revealed on the stand, and then she had said that in witness prep, maybe a day or two before that revelation, she had made mention of it in witness prep to the prosecutors. I also don't think, respectfully, that that is grounds for a mistrial, but I'm not the judge, and I respect the judge's ruling. She's charged with protecting the integrity of the case the way she sees fit, and I think that that's appropriate. In terms of the political ramifications, look, man, it is easy for someone who ain't never been in the ring to throw punches at someone who is. We can Monday morning quarterback the entire thing, but the only way to avoid ever being into some kind of a car collision is to never climb inside a car. These are the things that take place from time to time. They are regrettable. I'm extremely frustrated with the way that this case has taken this turn at this point, but I am committed to getting justice for the victims in this case and making sure that the prosecution is able to continue to move forward. But beyond that, man, I'm not one of those politicians that tries to hide from bad facts, or I won't take point on this when I talk to the media. I'll send someone else there. I'll try to move whatever hearing is going to happen until after the election. That's not the guy you're talking to. That's your traditional politician.
So what happens next with this case? And just give me 30 seconds. You redo it with the same expert, or how does that work?
I don't know. Frankly, I haven't had a conversation about what meaningful role this expert plays in this case. But the case is set for February. There'll be another hearing in October. I think it's almost middle October, probably based on motions the defense will file that will say, hey, we want even more sanctions than a mistrial. We want this case to be dismissed, or we want the charges to be reduced, or we want the evidence to be suppressed, or any number of things. And we'll go in and fight for the right outcome, and the judge will make a decision.
George Brauchler, District Attorney for the 18th Judicial District. Thanks for being here, George. I appreciate your taking the time to clarify some of these accusations that were made that,
Sure.
frankly, I didn't appreciate. But I'm glad you're here today. Thank you.
Thanks, man. Thanks for having me on. Bye.
Okay, I'll tell you what, folks, when we come back, I want to come back to this huge story of the day, the Brett Kavanaugh accusation, and talk about some aspects, the potential outcomes here that could have much bigger impacts than a lot of people are thinking about so far.
Tom Martino.